Amendment of Section 217(1)(a) that is prescribed to include all the colonels as justices of the peace because of their ranks. That's my submission, that before this Honorable Court, it has not been proven by the state that Colonel Mboto produced that certificate and proved that he was the justice of the peace. Same applies to Colonel Rapatu. Colonel Rapatu, when I came on board, I canvassed this aspect with him during cross-examination. He took out an appointment certificate and said he was appointed by Ria Pierre, the National Commissioner. That's not what is required. That's the submission of the defense. Number two. Sorry, my lord. May I just have a seat? Number two, the defense would like the court to look at the date, the time accused number one was arrested. He was arrested, I think it was 12 minutes past, it's 12:30, according to the evidence of the state, but that is not in dispute. When he was arrested, on the same day, at night, the state alleges that he volunteered in relating to the death of Senzo Meyiwa. And the state adamantly, and in terms of what Brigadier Gininda said, I was waiting for this time. There's something on my shoulders that I wanted to offload. This is the right time. The question is, if it was the right time in 2020, why it was not the right time in 2019 when he was arrested to offload that load? And the most important aspect that is important and which the defense will submit, that it was improper for for Colonel Mboto to take a confession, even Colonel Rapatu, without the assistance of the interpreter. This is what Judge, I think it's Judge Brook, in State versus Koki, this is what he maintained in paragraph 50, the relevance of an interpreter. That's why he mentioned that if the proformas and the statements attached thereto are made, paragraph 50, my lord.
Yeah, fine.
Yes.
If it may please the court, my lord, I'm reading from S versus Polki, the citation, I believe it's in Mr. Mgomezulu's arguments. At paragraph 50 thereof, the court remarked, all too frequently commissioned officers who record confessions do not use the services of an interpreter, that he or she and the suspect may both speak the same language. In this case, is Xhosa. It's not the only consideration. Questions on the proforma are set out in English, so too are recorded answers as have been made by the suspect. The statement itself is recorded in English. What is never known is the competency in English of any particular commissioned officer. He or she is not a sworn interpreter. In court proceedings, they most often give evidence making use of the services of an interpreter. The reliability and accuracy of the statement is frequently called into question. It is frequently asserted that the statement was not recorded correctly and was not read back to the suspect, whether in English or in the language of its origin. Many of the routine concerns surrounding the accuracy of the record of proceedings pertaining to the obtaining of a confession and the level of compliance thereof required by the Constitution of those taking the statement could be overcome by having the additional input of a sworn interpreter during the process. Interpreters form an integral part of the magistrate's court proceedings. They are almost invariably used by magistrates when confession is recorded. The comments made in Ntantiso can be added to by the observation that the use of an interpreter would also be of great assistance in the attainment of the constitutional goal, a fair trial. And then we go to paragraph 53 thereof, my lord. It says, and I quote, the time may well have arrived for the legislature to give serious consideration to the amendment of the CPA to remove the possibility that a confession may be recorded by a commissioned officer of the same force which is charged with the investigation duties. This would go a long way to ensure that the quality of the investigative work shows improvement, which is necessary to ensure an improvement in the rate of successful prosecutions for serious crimes in this country. I have little doubt that the members of the South African Police Services were aware that at some point during their investigation, there may well be magistral scrutiny of their background, leading to the recordal of a confession. There'd be a resistance on the part of the investigation team to resort to the improper use of police force or violence.
Yeah, thanks.
Thank you, my lord. That's the submission by the defense in relation to the pointings out that the state has led evidence that Colonel Hadebe, on the 5th of June 2020, accused number 1, pointed out freely and voluntarily. And in the same capacity as a commission officer, I submit that an interpreter was also not involved. The state must prove beyond reasonable doubt that a particular confession in terms of section 217 or a pointings out in terms of section 218 or an admission in terms of section 219 capital letter A must have been made freely and voluntarily in sound and sober senses without being influenced. That it's my submission that the state has dismally failed to prove those elements, those requirements. In the state's failure to prove those elements dismally, the state did not satisfy this court that the rights of both accused in terms of Section 35 of the Constitution were properly explained. And besides being the rights being explained to the suspect or to the accused person, accused 1 and 2, the question is, if accused number 1 was arrested on the 30th, if the law requires that he must be taken to court within 48 hours, and a confession was, as the state contended, it was already taken from accused number 1 on the 30th. Why was he still kept? Or why was he delayed from being taken to court? As I submit that when one looking at the definition of a confession, it's an unequivocal admission of guilt. So, in the premise of law, there is a prima facie case established by such a confession. Why was he not taken to court? Instead, the state used a strategy to investigate the case of Senzo Meyiwa whilst keeping the accused in custody for other matters. If I'm not going to if I'm not quoting my colleague Advocate Baloyi, in his submissions, he also mentioned something similar to what is happening in Durban in that case of AKA. Is the same strategy that is used in this court.
Which case is that now?
My Lord, is the one that...
Can this court take cognizance of that?
But I'm glad if the court mentions that, but it has never been canvassed to the state.
No, I'm dealing with the law. I'm not dealing with any other thing.
Yes, my Lord, but let's look at
No. That's gossip as far as I'm concerned. It's not law.
But
there's no judge who has found that this A, B, C, D. Please,
may I withdraw it?
Let's speak about law, not mlevo, gossip and whatever.
But that should have been conversed with the state as well, my Lord, yesterday.
No. You're arguing. He was making a comment about Durban.
That's what I wanted to do. May I retract that with due respect, my Lord?
Hello?
May I retract that?
Really.
Thank you, my Lord.
Mr. Mieko, do you quote Mlevo as a quote? Gossip. AK is arrested. He was driving. Where? Thank you.
Thank you. Thank you, madam. May I proceed?
Yes.
The rights of accused number 1 and number 2 were violated. As I've indicated in terms of the arrest was unlawful in respect of accused number 1. Number 2, there was no warrant of arrest when he was arrested for a murder case of Kwanongo. Up to now, the state has closed his case. Accused number 2 has never been taken to Kwanongo. It's my submission that he was unlawfully arrested and kept in custody. That violated his right to freedom. My Lord, another important aspect that I wish to submit before this honorable court relates to the dates in which these accused were charged, formally charged. Accused number 1 requested to see his fingerprints in order to prove that he was charged on the 26th of August. But the date of the statement given to accused number 1 reflected the 23rd of August 2020. So up to now, the state has not proven a evidence rebutted or submitted by accused number 1